Give me a little recap here. What just happened?
What just happened now?
Yeah.
I went to the counter of the clerk of the court and informed them that I had received information that we were expected to be there for 1 o'clock, and the clerk went off to seek information, and at that time Officer O'Day showed up and John started talking with her, and the clerk came back and told me that it was going to be at 1:30 in the first court. And we checked the docket. Our names aren't up on the docket at 1 o'clock. We'll see what the status is at 1:30.
Now, because you guys know about the whole Freeman thing, do you think they're going to try to make an example?
I have absolutely no idea which of the many courses they could be pursuing. If it's an amendment, what they should be doing is making sure that the thing is worded properly and that there are two separate ones, one for myself and one for my brother. The way they've got it now, they have the two of us attached as a his, which suggests some sort of contract or corporation which is not in existence, and they have no evidence of its existence. Their accuser is acting on the affidavit of an informant who is protected. The statement is that there's no other reason than to protect the witness. But elsewhere in the charges it says that they feel the case could be irreparably harmed if the witness was exposed for whatever. You have to read the charges. But the point is they're saying that the case would be harmed. So that is a second, possibly the primary consideration in keeping the accuser hidden. And the accuser, I'm sure I can catch out a lie.
Now, if you wanted to, sorry, did I cut you off there?
No.
If you wanted to, would you be able to go in there and basically appoint, like, okay, you got a charge, appoint them as your trustee, the Crown, and say, here, you settle this account then?
No, here, I'll take that again for now.
But then you'd have to be under your legal name, wouldn't you?
I'm going in right now defending my honor as a peace officer. I have a security agreement that puts my spiritual being in control of my corporation. I have limited discretionary powers as a peace officer. I'm working for the RLS Corporation and Phoenix Steers and Rick Simpson all at the same time, and that's what I'm here to represent, is that status, because the last time we had contact with these people, they jumped on peace officer Freeman Allen of the Spenceley family and dragged him off. And then when I lost custody of my person, I then became alien, which is the proper way to pronounce my given name, and that was given to me by my parents so that I might respond in private communications with them. Anyone who's been using my private name for public purposes is indebted to me and my parents. They were the creators, and I am the beneficiary of that creation of that name. These people call it Allen. They don't even know how to pronounce the name.
John?
I did a little research this morning, and presently, as near as I can find, there still isn't any overturn of Judge Barry Strayer's ruling that there's no law on marijuana in Canada. In fact, quite the contrary. There was a case held before the Federal Appeals Court in 2008. It was a tribunal, and they ruled that he, in fact, was completely and utterly right in ruling that way. And they didn't expound upon it, but they did say that he had expounded very well upon it. And I will expound upon what he said now. What he said was, until the medical community is in agreement with the new laws, there are no laws. Well, as far as I know, the latest laws made were written in the newspaper the very next day that the medical community's up in arms. So that reverts to Judge Barry Streyer's ruling that there are no laws. So they need to go back to square one and try again. And other than that, the NDP party is putting a bill through Parliament right now to put 600,000 criminal charges waived from all the people who have been charged with marijuana for the past 25 years, I believe it is.
Yeah.
600,000.
Well, then all those people will be suing the government for unlawful arrest, wouldn't they?
They'd have a damn good case.
They could. They could.
I'd like to make a mention of the concept of mens rea. It literally transliterates as criminal intent. Okay, it's not a translation, it's a transliteration. It's without criminal intent, there is no crime.
For what it's worth, what would be the point in suing a corporation that has no money and operates out of your pockets? You'd be suing yourself, is what you'd be doing.
That's true.
Oh yeah.
You're just better off to take your secured party finances and walk away when they'll let you. But here we are in court. They just won't let us be, so we're going to have to charge them our fee schedule because they got a copy of it in registered mail. And this judge should have recused himself before now because he was mentioned in a lawsuit of
Counterclaim.
in the counterclaim. Malicious prosecution. He should have recused himself before this time, and as he hasn't, then I think we'll be having to file this before the World Court.
To explain what that means.
Look out, here we're coming.
This Judge Irwin Lambert, the person Irwin Lambert acting as judge for the provincial court, his signature is on the warrant that initiated the wrongful procedure, and he also sits as judge over the plea and deems. Well, his status as an employee of the government and a officer of the court puts him in a position where he can only deem over his charges, and I'm not one of his charges. I'm acting as a sovereign, which means that as soon as I accept his oath, put him in contract with me, I am his boss. I don't want to go there. I don't want to hire someone who performs the performances I've seen him enact.
Well said.